I'm going to go through some disturbing information. I'm going to go through some of the international law that's applicable to nuclear weapons. All of this may not be the most entertaining sort of information, but I think it is something that we need to understand in this country because the United States led the world into the nuclear age, and the United States needs to lead the world out of the nuclear age. Brian Watson, one of the defendants, gave me the topic from Auschwitz to Trident. And a very good topic it is for me because it was mentioned I wrote my PhD dissertation about international law and nuclear weapons, and one of the things I focused on was international law as applied in the Nuremberg cases and how that bears upon the question of nuclear weapons. Auschwitz, of course, was a Nazi concentration camp and extermination center with gas chambers in Poland. The overall numbers of victims from 1940 to 1945 is estimated at between 1.1 and 1.5 million people. The majority of the victims were Jewish. Most of the Jewish victims died in the gas chambers. Other victims included Poles, Gypsies, Soviet prisoners of war, and prisoners of other nationalities. Okay. That is Auschwitz. Now, what about the Trident nuclear submarine? Well, there's no official governmental information available on it, but there's some pretty reliable estimates so far as we can tell from the Natural Resources Defense Council. You can find all this on the website of the Bulletin of the Atomic Scientists, thebulletin.org. It appears that at Bangor, here in Washington State, there are 9 Trident submarines now based there. Perhaps half of them are out on patrol at any time. Each of those submarines can carry 24 Trident II missiles. Those are long-range missiles, several thousand miles. Each missile can carry a re-entry vehicle with up to 6 warheads in that vehicle, which then get dispersed to different locations. So each submarine could have about 150 warheads. There are 1,100 W-76 warheads at Bangor. They carry a kiloton yield of 100 kilotons. The Hiroshima bomb that devastated the city of Hiroshima, if you ever had a chance, it's really worthwhile to visit Hiroshima and Nagasaki, was about 15 kilotons. So 100 kilotons is 7 times larger than the Hiroshima bomb. There are also 264 W-88 warheads at Bangor. Those are 455 kilotons, nearly half a megaton. So those are 30 times the yield of the Hiroshima bombs. So let's say a submarine was carrying the W-76 100 kiloton warheads. That would mean it was carrying, just one submarine was carrying 14.4 megatons or 14 million tons of explosive power, 14,000 kilotons, about 1,000 times the Hiroshima bomb. So that's the power of the Trident submarine and its missiles. It's essentially not imaginable. Each Trident warhead, just one Trident warhead is a potential holocaust. It can destroy a city. Ted Taylor, the nuclear physicist turned anti-nuclear abolitionist, used to say that the power of nuclear weapons is off the human scale, and indeed it is so. One other fact that you should know about Bangor, there are other warheads stored there as well, beyond the ones that are actually deployed on the Trident submarines. Natural Resources Defense Council estimates that almost 2,400 warheads are in storage at Bangor. That includes submarine-launched cruise missile warheads. So like it or not, and I imagine you don't like it, Seattle is pretty close to one of the largest nuclear warhead storage areas in the United States. What did you say it was, Brian? The largest. Now, the number of submarines at Bangor has been built up over the last few years to increase the U.S. Pacific presence. I'm going to throw some jargon at you, and we can talk about what this all means and question and answer for those of you who are interested. But just to give you an idea of how the military talks about this, the Rear Admiral Charles Young, director of the Navy's Strategic Systems Program, said in an August 2002 speech that the buildup of the Trident II D5 missiles in the Pacific enhances system accuracy, payload, and hard target capability, thus improving U.S. available responses to existing and emerging Pacific theater threats. In other words, the United States is building up its nuclear capabilities in the Pacific to have more leverage vis-a-vis China. Now, what damage can a Trident submarine inflict? Well, the answer is in the millions or the tens of millions of casualties. It, of course, depends on the circumstances, but you can get an idea of the scale from this. The Bulletin of the Atomic Scientists recently estimated that use of 50 warheads could cause 200 million deaths. That's in the statement regarding the movement of the doomsday clock from 7 minutes to 5 minutes to midnight. That move was just made in the last few days by the Bulletin of the Atomic Scientists. Now, why compare Auschwitz and Trident? Bishop Hunthausen used to refer to Trident as the Auschwitz of Puget Sound. What's the basis for the comparison? Well, first of all, the scale of deaths that would result from use of Trident. If Trident is never used, of course, this comparison fails, and I'll return to that question. There's another comparison. It's in the nature of methods used. Dr. Reddy, an eminent Indian scientist, described in an essay how his visit in September 1999 to the former Nazi concentration camps in Poland intensified his oppositions to the Indian nuclear tests that were carried out in 1998. He compared the methods and he identified them as the scale of the killing, the recruitment of capable minds, the harnessing of science and technology, the extent of organization, the resort to efficient project management methods. Now, he was comparing the bombings, the US atomic bombings of Japan in World War II and Auschwitz. But what I want to draw your attention to is a point that's been made before, but we need to keep it in mind. This is sort of a vast bureaucratic slash technocratic rationality at work that can result, if we let it, can result in millions of deaths. Now, why is more attention not paid to Trident and to the US nuclear arsenal, which is about 10,000 right now, with more than 4,000 warheads deployed in various ways? Well, one part of the answer is that there's not very much information about it readily available. You don't see the media commonly reporting that the US has 10,000 nuclear warheads. A poll was done of Americans regarding how many warheads they thought the United States had, and they said 200. And they said, and it would be a good idea if the number was reduced to 100. And generally, Americans, when polled, about 2/3 of them say they support global abolition of nuclear weapons. So one answer is the lack of information, which I think shades over into denial. People don't know, and they don't really want to know either. A second part of the answer is the assumption that the nuclear weapons are not going to be used. They haven't been used for 60 years in war, anyway, since the United States bombed Japan. So there seems to be an assumption on the part of many that, and they're not going to be used in the future. Everybody understands they wouldn't be used. Well, if that's true, why have them in such number and in such aggressive deployments? But I think this is a comforting but wrong assumption. During the Cold War, the United States and Soviet Union came close several times to waging nuclear war. Former commander of U.S. Strategic Forces Lee Butler said that we escaped nuclear war during the Cold War by the grace of God. It is certainly possible, you know, you might even predict it, but it's certainly possible that during the coming years and decades, serious hostility will again arise among the world's major powers. And certain parts of the U.S. government appear to be planning for that eventuality with respect to China. So it seems pretty obvious to me anyway, we should take advantage of this time of relative stability and cooperation to eliminate or seriously reduce the threat of nuclear war. There are signs that the problem is starting to be taken seriously again. Of course, it was taken seriously once upon a time in the 1980s. There's a 2006 report of the Weapons of Mass Destruction Commission headed by Hans Blix. Their report is entitled Weapons of Terror, Freeing the World of Nuclear, Chemical, and Biological Arms. My organization has a project of responding to that report and describing what its implications are for U.S. policy. Somewhat surprisingly, on January 4th, there was an op-ed in the Wall Street Journal by former high U.S. officials George Shultz, William Perry, Sam Nunn, and Henry Kissinger, calling for reassertion of the vision of a nuclear weapon-free world and detailing steps to implement that vision. There is the recent move of the doomsday clock, which gathered quite a bit of attention. And then there is the activism that we are sort of paying tribute to tonight. And there is similar activism taking place in the United Kingdom, really in Scotland, where there is serious local regional opposition to the replacement of the United Kingdom's Trident nuclear submarine system. Now, as my introduction pointed out, I've spent a lot of time thinking about international law, and that's what I want to talk about for the rest of the time I'm going to take. And let me start out with Nuremberg law. The International Military Tribunal, sitting at Nuremberg, convicted high Nazi officials for the commission of war crimes, crimes against humanity, like those perpetuated at Auschwitz, and crimes against peace, planning and waging a war of aggression. The tribunal was established by the victorious Allies, United States, Britain, France, and the Soviet Union. The Nuremberg Tribunal, for the most part, did not deal with combat operations, like the bombing of cities conducted by Germany and also later on a large scale by the Allies. Rather, it focused on murder and other ill treatment of prisoners of wars and civilians in occupied territories, like in the Soviet Union. These were war crimes. Murder, ill treatment, inhumane acts, and extermination of civilian populations in Germany and in occupied territories like Poland, in concentration camps and gas chambers. These were crimes against humanity. In most circumstances, they were also war crimes. Finally, the launching of aggressive war, which was known as the crime against peace. So the lessons for nuclear weapons policy from the Nuremberg case law really is not about the rules that apply to the conduct of warfare in the sense of combat operations. They're larger lessons, really. First of all, the Nuremberg principle of individual responsibility. It's quite clear in the statute establishing the Nuremberg Tribunal that leaders who planned and committed or were complicit in atrocities can be prosecuted for international crimes, regardless of whether their acts were done pursuant to national law or superior's order. Ordinary soldiers who carried out obviously unlawful orders were also liable to prosecution. So the conclusion I draw, and this is based partly what I'm going to go through in the rest of my talk, the conclusion I draw from the Nuremberg principle of individual responsibility in part is that all persons, military and civilian, whatever their rank or position, are obligated to terminate their commission of or complicity with acts connected to the use of a nuclear weapon in violation of international criminal law. Other lessons of Nuremberg. Large-scale atrocities against civilian populations are crimes against humanity. The Nuremberg tribunals, there was more than one. There was the first tribunal, the International Military Tribunal. Then there were 10 subsequent trials of major war criminals. So the tribunals together rejected the Nazi doctrine of total war. I think it was the International Military Tribunal described the doctrine as saying that the moral ideas underlying the conventions, like the Hague Conventions, which seek to make war more humane, are no longer regarded as having force or validity. That's the doctrine of total war. The Nuremberg tribunals also rejected the notion that military necessity justifies overriding the rules of war. One tribunal said that the rules must be followed even if it results in the loss of a battle or even a war. The tribunals rejected ideological reasons for violations of the rules. Interestingly, one of the driving motives for the war crimes in the Soviet Union was the Nazi conception that Bolsheviks were sort of so evil that they didn't warrant ordinary humane treatment. Well, the Nuremberg tribunals said that ideological reasons of that kind are no justification for not following the rules of war. So in the case of nuclear weapons, military necessity, alleged military necessity, you know, you say you have to destroy a certain target by a certain time, or the notion that you're fighting against an evil enemy, these sorts of justifications were rejected by the Nuremberg tribunals. Now, is Nuremberg law still relevant? For decades, nothing was done to follow up on the Nuremberg precedent. But then in the 1990s, the UN Security Council established ad hoc international tribunals for the former Yugoslavia and Rwanda. Other international tribunals or hybrid domestic international tribunals have been established, as in Sierra Leone and Cambodia. Most importantly, in 1998, the Rome Statute of the International Criminal Court was negotiated. Now more than 100 countries are parties to that treaty. Most of you probably know that does not include the United States. The Bush administration has rejected the Rome Statute. In fact, has undertaken rather far-reaching efforts to undermine the International Criminal Court. The Rome Statute entered into force and the court began operating in 2002. The chief prosecutor is now investigating alleged international crimes committed in Uganda and Darfur/Sudan. The Rome Statute contains definitions of crimes against humanity, drawing on but going beyond the Nuremberg Charter. It also defines war crimes and the crime of genocide. It defines the circumstances under which individuals can be prosecuted. And again, as in Nuremberg law, there is no excuse for heads of state or for persons who say they were following superiors' orders or national law. So the statute of the International Criminal Court is carrying forward the Nuremberg legacy. There was another development in the 1990s which was not as directly carrying forward the Nuremberg legacy, but which certainly was an assertion of the relevance of international law to the problem of nuclear weapons. That was the advisory opinion of the International Court of Justice on nuclear weapons issued in 1996. Supported by a global civil society campaign, and that was key to the success of this effort. The UN General Assembly asked the International Court of Justice to provide legal advice regarding the legality of threat or use of nuclear weapons. In its 1996 opinion, the court approvingly cited the Nuremberg judgment, but this was not a major theme. Rather, the court more generally focused on international humanitarian law governing the conduct of warfare codified in the Hague and Geneva Conventions and elsewhere. The court concluded that the threat or use of nuclear weapons would generally be contrary to the rules of international law applicable in armed conflict, and in particular, the principles and rules of humanitarian law. This conclusion is powerfully supported by key elements of the court's analysis. They include, this is probably the most important statement in the opinion. The court said that one principle is that civilians must be protected. There must be a distinction made between military targets and civilians. Therefore, states must never make civilians the object of attack and must consequently never use weapons that are incapable of distinguishing between civilian and military targets. Well, that's pretty clear, isn't it? The court also cited environmental considerations, saying that they must be taken into account in assessing the lawfulness of the use of a weapon. The court said that the nuclear weapon states had failed to demonstrate that any use of nuclear weapons could comply with legal requirements or avoid catastrophic escalation. The court said if the use of force itself is illegal for whatever reason, the threat to use such force will likewise be illegal. So if the use of nuclear weapons is illegal, the threat to use nuclear weapons is also illegal. The force of the holding that threat or use is generally illegal is thus overwhelming when viewed in the context of the entire opinion. It was qualified by the statement that the court cannot conclude definitively whether the threat or use of nuclear weapons would be lawful or unlawful in an extreme circumstance of self-defense in which the very survival of a state would be at stake. In explanation, the court referred to the right of self-defense, the policy of deterrence, whose legality the court declined directly to assess, and to the fact that there were certain elements of fact that were not at the court's disposal. However, if you examine the opinion, you can see that the court is quite clear that in any circumstance, fundamental rules of international humanitarian law apply to the possible use of nuclear weapons. States must never use weapons incapable of distinguishing between civilian and military targets. That taken as a whole, the court's opinion supports the illegality in all circumstances of threat or use of nuclear weapons was explained by a body very knowledgeable regarding the realities and doctrines of nuclear weapons. That's the Committee on International Security and Arms Control of the U.S. National Academy of Sciences. The committee stated that the ICJ, the International Court of Justice, unanimously agreed that the threat or use of nuclear weapons is strictly limited by generally accepted laws and humanitarian principles that restrict the use of force. Any threat or use of nuclear weapons must be limited to and necessary for self-defense. It must not be targeted at civilians and be capable of distinguishing between civilian and military targets. And it must not cause unnecessary suffering to combatants or harm greater than that unavoidable to achieve military objectives. That's a very nice summation of the court's analysis. The Committee of the National Academy of Sciences went on to say this: in the committee's view, the inherent destructiveness of nuclear weapons, combined with the unavoidable risk that even the most restricted use would escalate, makes it extremely unlikely that any contemplated threat or use of nuclear weapons would meet these criteria. Now again, the people who wrote these words were people who knew a whole lot about US nuclear weapons and US doctrine about possible use of nuclear weapons. These statements are certainly true. They are certainly true of the Trident submarine and its 100 kiloton and 455 kiloton warheads. Now, so far, I have approached the problem of Trident from the angle of international law relating to war and its conduct. There is another important perspective: the obligations contained in the Non-proliferation Treaty, the NPT. 188 states are members. Only 4 countries are outside the regime, all nuclear armed: India, Pakistan, Israel, and North Korea. The NPT strikes a bargain between non-nuclear weapon states, which are prohibited from acquiring nuclear arms and are guaranteed access to nuclear technology. So the bargain between the non-nuclear weapon states and the nuclear weapon states, those states are committed to the goal of disarmament. I think this has all become a little more familiar due to the constant coverage of the situation in Iran over the past couple of years. What I want to focus on is Article 6. Article 6 of the Non-proliferation Treaty says that the states parties, including nuclear-armed Britain, China, France, Russia, and the United States, agreed to negotiate in good faith on nuclear disarmament. The International Court of Justice interpreted Article 6 in its 1996 opinion. The court unanimously held that there exists an obligation to pursue in good faith and bring to conclusion negotiations leading to nuclear disarmament in all its aspects under strict and effective international control. Talk is not enough. Talk must lead to action. Now, every 5 years, the states parties to the NPT hold review conferences to assess implementation of the obligations of the treaty and to look to the future. The 2000 NPT Review Conference specified what the Article 6 disarmament obligation requires. Its final document was approved by the United States and all other participating states. It set forth 13 practical steps for the systematic and progressive efforts to achieve nuclear disarmament. That's a quote. It's an agenda for the achievement of a nuclear weapon-free world. Reinforcing the holding of the International Court of Justice, a key element is an unequivocal undertaking, I'm quoting, by the nuclear weapon states to accomplish the total elimination of their nuclear arsenals. So they said quite clearly, what we're required to do under the NPT is eliminate our nuclear arsenals. The NPT Review Conference in 2000 also specified other steps, and I've singled out a few of them. Entry into force of the Comprehensive Test Ban Treaty, negotiating a treaty banning the production of fissile materials, highly enriched uranium, plutonium, for weapons, applying the principle of irreversibility to nuclear weapons reduction and elimination. Irreversibility means saw up the missile, dismantle the warhead, develop verification, reduce the operational status of nuclear weapons. Well, how do you do that? Well, you bring the Trident submarines back to the base, take the missiles off the submarine, you take the warheads off the missiles. Then at least it takes a certain amount of time to get in the position to launch those warheads. So de-alerting, as this is called, involves lengthening the time required to initiate nuclear war from days to weeks to months. It's not the same as the verified elimination of nuclear arsenals, which in fact is a challenging task. And the reason it's a challenging task is that the Soviet Union, then Russia and the United States accumulated vast stocks of fissile materials and warheads. It's going to be a challenging mission to account for and be confident about the elimination of all those warheads and the stocks of fissile materials. But it is possible to take the weapons off alert, to take them off deployment. And it's possible to do the verification too. It's just going to take some time. Another commitment made in 2000 was to a diminishing role for nuclear weapons in security policies to minimize the risk of their use and to facilitate their elimination. In subsequent UN General Assembly resolutions, the world's governments, not including the United States and India, but almost all the world's governments have overwhelmingly approved the 2000 NPT agenda. Nearly all governments in the world are now on record as favoring application of the principles of transparency, irreversibility, and verification in the process of working towards the elimination of nuclear weapons and other commitments made in 2000. Now, is US policy consistent with these commitments? No, it is not, and it would actually be a rather long discussion of all the ways in which the US is not in compliance with the commitments it has made. But let me just say briefly, first of all, regarding Trident itself, the buildup at Trident is not consistent with the commitments made to a diminishing role for nuclear weapons and to the reduction of their operational status. Indeed, the United States remains capable of firing more than 1,500 warheads, including those on patrolling Trident submarines on a half-hour notice. Russia has a capability to fire several hundred warheads on short notice. In other words, incredibly, we are still in the situation of the Cold War nuclear standoff. There are no negotiations going on concerning reductions of US, Russian, and other states' nuclear forces. Let me repeat that. There are no negotiations going on concerning reductions of nuclear forces. That despite the fact that there are 27,000 nuclear warheads in the world today. The 2002 Moscow Treaty, not really a treaty, it was just a two-page document, contained no requirements for the dismantling of delivery systems like Trident or the Trident missile or warheads. Basically, what the Moscow Treaty did was to say the Bush administration is planning to reduce the US arsenal to no more than 2,200 deployed strategic warheads by the year 2012. So it was like a ratification of a plan that had already been made by the Pentagon. Again, it did not require verification of the reductions. It did not require dismantling of the delivery systems or the warheads. The US is heading towards having an arsenal, NRDC estimates, of about 6,000 in the year 2012, and about 2,000 of those would be long-range strategic deployed warheads. The US has not ratified the Comprehensive Test Ban Treaty. No negotiations are underway now on a treaty to control fissile materials. In sum, US actions, from the continued deployment of Trident to the lack of any negotiations on reductions to the rejection of the Comprehensive Test Ban Treaty, demonstrate that the United States is not in compliance with its NPT disarmament obligation. Now, I want to wrap up, and I want to end by talking a little bit about nonviolent direct action in opposition to Trident. Brian Watson, Shirley Morrison, Carol Ann Burroughs, and others involved but not prosecuted for their participation in the August 2006 demonstration and blockade of traffic at Bangor deserve our deepest gratitude. They are keeping the spirit of nonviolent peacemaking of the Ground Zero Center alive. And they are carrying forward the Nuremberg principle of individual responsibility. The Nuremberg Tribunal famously observed, quote, "The very essence of the Nuremberg Charter is that individuals have international duties which transcend the national obligations of obedience imposed by the individual state. Direct actionists engaged in reasonable and nonviolent acts are extending the Nuremberg principle of individual responsibility. True, they have no direct involvement in US nuclear weapons, and therefore they have no theoretical legal vulnerability for being complicit in plans for the use. Nonetheless, as citizens and taxpayers, they have at least a political involvement, and they are acting to say, we want to terminate that political complicity. We declare our non-acceptance of ongoing reliance on the Trident system. Here's another way of seeing their action. I talked about the Non-proliferation Treaty obligation of good faith negotiation of nuclear disarmament. Well, I see these defendants as citizens engaged in good faith implementation of their nation's disarmament obligation. Thank you.
The question is, what's the effect of quoting international law in an American court, and how are judges likely to respond to international law as opposed to invoking American law?
Well, international law is part of American law. Under the US Constitution, treaties are part of the supreme law of the land, along with laws passed by Congress and the Constitution itself, binding upon judges in every state. And an instruction to this effect was given to the jury in 1999, and I think it helped make the jury more receptive to the arguments, the testimony of Brian Watson and others. Courts in the United States have evolved various ways of not having to deal with international law when there's a challenge to a fundamental US foreign policy at stake. In protest cases, the federal courts have generally said that, say, blocking access to a nuclear weapons base does not raise the question of the legality of the weapons directly enough to require the court to go into it. Perhaps they would not make the same argument if, say, somebody like Daniel Ellsberg disclosed classified information about a planned use of a nuclear weapon. Maybe that's the kind of scenario they have in mind where there would be a more direct question. Courts also sometimes say that questions of foreign policy involving international law are matters for Congress or the president. But, you know, things change. And the fact is that the United States is part of a global system. There's no escaping it. And so the US Supreme Court recently said that, yes, indeed, the United States does have to follow the Geneva Convention in treatment, in detaining and treating detainees under the so-called War on Terror. There's been a case recently that involves implementation of US commitments under the Ozone Treaty, the treaty to prevent depletion of ozone. And the court in Washington, D.C. Grappled rather assiduously with the question of whether the Natural Resources Defense Council could come into a US court and enforce a commitment that the United States had made in the context of that treaty. And the court said, no, you can't do that. But it was one of those cases that made me think, someday a court is going to answer yes to that question. Generally about international law, one of the questions is, well, how can it really be law if you can't enforce it? And that's, that's a legitimate point to raise. But I think that the answer to that question at bottom is to say that international law is going to be enforceable in this country when it becomes part of our political culture and it becomes something that we demand of our country and our politicians. And this is something that it actually is part of political culture in other countries. So this is not some kind of fantastical thing that I'm imagining. It's much more part of the stuff of politics, say in Britain or Germany or Japan than it is here.
Another question? Yes, in the back. What is the International Court of Justice and what kind of jurisdiction, if any, does it have in the United States?
Well, the International Court of Justice is the judicial branch of the United Nations, and it adjudicates disputes among states. It also gives advice on legal questions when asked to do so by organs of the United Nations like the Security Council or the General Assembly. The United States accepted the jurisdiction of the International Court of Justice in the 1940s and 1950s and subsequently withdrew from the court's jurisdiction in the 1980s when the court was ruling against the United States in a case brought by Nicaragua challenging U.S. support of the counter-revolutionaries, the Contras in Nicaragua. The court has been in the news over the last few years because cases involving violations or alleged violations of a treaty of, I think it was the Vienna Convention, requiring that consulates be notified when, say, a Mexican national is being prosecuted for a serious crime in the United States. So that is an instance of a treaty which arguably was enforceable in the U.S. courts. It didn't get all the way there. The Supreme Court didn't come down in the end and say, you must abide by this agreement. Now, the nuclear weapons case is a case involving an advisory opinion. That's sort of like, the governor of Washington State asked the Attorney General of Washington State, what's your advice on a certain legal matter involving taxation, say? Well, it's the same sort of process. The UN General Assembly asked the legal advice of the International Court of Justice on the legal status of nuclear weapons. Well, I'm making it sound like it doesn't amount to much, but in fact it does, because the court is the highest court in the world on questions of international law. They were interpreting law which states acknowledge to be binding. The United States says we are complying with the Nuclear Non-Proliferation Treaty disarmament obligation because we've reduced the number of our warheads from 32,000 in the 1980s to about 10,000 now. And we're going to be down to 6,000 in a few years. So the United States acknowledges that it is bound by the obligations of the Non-Proliferation Treaty. The United States says that we comply with the rules of humanitarian law, forbidding attacks on civilians, forbidding indiscriminate harm, and so on. So when the court was interpreting the rules of humanitarian law or the meaning of the disarmament obligation in the Non-Proliferation Treaty, it was interpreting law which states acknowledge is binding on them. Therefore, it's an authoritative opinion, and it's certainly worth the time to read.
Can you see any way, and this applies not only to Israel but also the United States has been said to consider this also, that the use of tactical nuclear weapons, say against Iran, can be justified under international law? I'd
like to answer that question by starting out with just a little bit of background on on trends in U.S. nuclear doctrine. I pointed out that in 2000, the United States agreed with other countries to a diminishing role of nuclear weapons in security policies. The trend has been just the other direction. The 2001 Nuclear Posture Review of the Pentagon talked about using nuclear weapons in a wide range of circumstances, identified 7 potential target countries, including North Korea, Iran, and Iraq. More recently, Seymour Hersh has been reporting in the New Yorker that at the very highest levels of the civilian levels of the US government, there was insistence on retaining the nuclear option in plans or, potential plans for military strikes against Iran's nuclear program. And Hersh further reported that the Joint Chiefs of Staff eventually were able to prevail and that the nuclear option was taken out of the plans. So one of the many disturbing things about the last few years is that at least the paper or that doctrinal talk about U.S. use of nuclear weapons has been escalating. Now, regarding Iran, first of all, I think it should be said that unless Iran is posing a threat of imminent attack against another country, or unless use of force is approved by the Security Council, any sort of military action against Iran by any country, US, Israel, anybody else, is illegal, just as the US-UK attack on Iraq was illegal. I don't think that it's very likely that the United States or Israel would use nuclear weapons unless some rather extraordinary circumstances arose. That's one of the problems with engaging in wars, is extraordinary circumstances can develop in wars. So I find it quite unlikely that there would be use of US or Israeli nuclear weapons in some kind of initial military action against Iran. On the point of whether it's legal or not, the nuclear strategists can draw up scenarios where they use relatively low yield warheads, which still cause very large amounts of destruction against isolated targets, in deserts, for example. But from what I've seen, the potential targets in Iran, first of all, are located in or near populated areas. Secondly, they are hardened against, to some extent, they're protected against potential attack. So the use of nuclear weapon in those circumstances almost certainly would violate the prohibitions on causing indiscriminate harm and unnecessary suffering.
In the front over here. Yes. The question for folks who didn't hear it is, what are the consequences if somebody is found to be violating these laws prohibiting, say, the use of nuclear weapons? What are the sanctions?
Right. Well, that's something we don't really want to find out. We don't want the nuclear weapons to be used and then find out whether there are any, legal consequences for. I'm not saying you want but it is. I was trying to reach this point earlier when I said that people rightly ask, how can you talk about international law as being law if it's not readily apparent exactly how it's going to be enforced? My answer to that remains the same. For international law to really make a difference, be part of US foreign policy decision-making, it's going to have to be because the American people says it should be part of US foreign policy decision-making. You know, the UN Security Council is not going to tell the United States, you know, you must comply with international law in XYZ circumstance. You know, the United States has a veto on the Security Council. The United States is the most militarily powerful country in the world. It's just not a plausible circumstance. Now, other countries are in different positions, and so when Iran is the subject of a resolution by the UN Security Council, which calls for the imposition of limited sanctions because of Iran's ongoing program to develop the nuclear fuel cycle, it's, you know, it seems to be having an effect so far as we can tell. You know, what's coming out of reporting in Iran on current internal politics there. So the enforceability of international law, unfortunately, it depends partly on where you sit in the international system.
The question is, what kind of law covers the replacement of wearing out and aging warheads with the new warheads and warheads that might be either equivalent or more highly developed?
The same question also arises with respect to the replacement of the UK Trident system. And other countries like France in particular are certainly engaged in rather aggressive modernization programs. It's not that they're installing completely new types of warheads and completely new types of delivery systems, but in the course of replacing the existing systems, they're doing some improvements, you know, and that almost certainly would be the case if the Department of Energy is allowed to go forward with its program for the reliable replacement warhead. It's very, very likely that there will in fact be some additions to military capabilities made along the way. There is nothing specific that I can point to, for example, in a 2000 NPT commitment that bears directly on this question. And one of the things, by the way, that we are talking about doing, and we've been consulting with governments about doing, is going back to the International Court of Justice to get some clarification on what does the obligation of good faith negotiation of nuclear disarmament require as a matter of law. Because as now stated by the court, it is fairly general. Bring to a conclusion negotiations on nuclear disarmament. But my answer to your excellent question would be that if the United States and the other nuclear-armed states are projecting that they are going to have nuclear weapons for decades to come, and they're modernizing their forces and they're modernizing their complex, then they are not in good faith planning and preparing for security without nuclear weapons, which you need to do if you're going to negotiate nuclear disarmament in good faith. In the report that I mentioned earlier, it's called Weapons of Terror by the Weapons of Mass Destruction Commission. One of the things they say is that the nuclear countries that now have nuclear weapons must begin planning and preparing for security without nuclear weapons. I don't think the reliable replacement warhead program falls into that category.
The question, I couldn't hear all of what you said, but the question regards the assertion that the deployment of nuclear weapons as a deterrent or as a strike frees up U.S. forces so that they don't have to be on the front line, basically, so that those weapons in turn become a tool of our foreign policy and are useful in that respect. How do you respond to that?
Right. Well, it's a hard question because it starts getting you into the nature of U.S. strategy and U.S. politics, you know, U.S. politics vis-a-vis the world. I think it's I think it's probably fair to say that U.S. nuclear forces operate, and this is something that our friend Andy Lichterman says, it operates as a sort of an umbrella under which conventional forces operate, so that when, the United States sends its forces, its troops to the Middle East, everybody knows that the United States also has a nuclear capability, and so that's sort of there in the background, sort of as a backstop, if you will, to U.S. deployments. Now, other people would say, well, including people who have been in the nuclear business, they would say, well, that's really not doing very much for you. That's more of a kind of a theoretical advantage than a real-world advantage. So, opinions differ about the effect of that approach regarding nuclear weapons, but it's certainly the case if you spend your time reading Pentagon doctrinal statements. That's what they say. They say our nuclear deterrent allows us to project force in the world, and so forth and so on. And so you then start having to think, okay, if the United States is going to take seriously the mission of leading the world out of the nuclear age, what would be the consequences for the rest of its foreign policy? And would that require the United States to become much less aggressive or militaristic in other aspects of its foreign policy to make that possible? Or would you have to go beyond that? Would you have to see reductions in non-nuclear offensive forces in order to make nuclear disarmament possible? Somebody might say, well, really, when you get down to it, a country like Russia is not going to give up its nuclear weapons if it knows that the United States is capable of hitting it with very effective non-nuclear missiles, say. So this is the sort of question that you get into when you start thinking about the elimination of nuclear weapons, and there are questions that we really should be thinking about, and I think they will lead in good directions for the way that our country should behave in the world.
Dr. John Burroughs, thank you.